One.
Now, one more question is asked of Ken Starr, relevance to events that are taking place, and that is Ken Starr on the Morning Schmo with Mr. and Mrs. Schmo. Can a president be subpoenaed? Can a president be subpoenaed? Cut 11, go.
I'm curious what your opinion is about a president's ability to just ignore a subpoena from a federal court if he chooses to.
Well, I love Rudy, but Rudy was right then, and as I described in the book, the takeaway from the book is Rudy is not correct now. It is, in fact, the case, as I describe in the book Contempt, that the president is subject to subpoena.
All right, let's stop. Ken, you're not a judge. You're not a Supreme Court justice. The question Scarborough asked wasn't whether you could, process-wise, trigger the issuance of a subpoena. The question was about quote, the president's ability to just ignore a subpoena from a federal court. That was the question. And the more particular response should be, it depends on the subpoena. If the subpoena is for documents, we know in the Nixon case with the tapes, the Supreme Court has ruled yes. But as for the physical appearance of a president in front of a grand jury, or some alternative, such as the physical interviewing of a president or commanding a president to answer questions, you know full well, Ken, that's never happened. Well, it happened in your case with Clinton because that's the deal you cut with Clinton. But in terms of an adjudication of that issue, that's never happened. Ever. Because most prosecutors would never try it. Go ahead.
We were pushed back by the White House during the Lewinsky phase of the investigation. We invited the president through letters 5 times to come before the grand jury and to give an account before the grand jury. Push back, and so I authorized the issuance of a subpoena. Promptly, with his very able lawyers from Williams and Connolly, we reached a resolution that is now part of history.
Yes, you reached a resolution because Clinton actually was and had committed perjury and obstruction. Now, Trump hasn't committed anything. Trump hasn't done anything. To question the President of the United States about a presidential prerogative to have an inferior employee, if in fact he is, question the President of the United States, his boss, about a decision that a president has every right to make under Article 2. He is the executive branch, such as the firing of the FBI director. Is absolutely not the same thing as what you're talking about, Ken Starr, and you damn well know it. And you know it. So the nature of the subpoena, is it a ducis tecum subpoena? What is it? What is the subpoena seeking? The physical presence of the President of the United States in front of a federal grand jury to answer questions about his prerogatives? No, a president is not required to comply with that. He should fight it all the way to the Supreme Court, and that's exactly what we're talking about in the Mueller case, which is quite distinct from the Clinton case. But Scarborough, he doesn't care, and Brzezinski, she doesn't give a damn. So what Clinton did under that fact pattern, as the law applies, has nothing to do with Donald Trump's situation. Nothing. So I wanted to clarify that, and it's too bad Ken Starr wasn't here to discuss this one-on-one. I would have loved to have done that, but it just wasn't in the cards, apparently. Wasn't